Good morning, everybody. This is the regular meeting of the Board of County Commissioners for the date of Wednesday, June 1st. Welcome to this meeting. Thank you for being in attendance here in the meeting room as well as on TV. And some people do watch by YouTube or by streaming video, so thank you for being with us however you watch this meeting. We do have a busy meeting today. It's a kind of a simple meeting. However, we have no resolutions. We have no fire district meeting and no executive session, so it's a little bit unusual, I suppose. We do have a couple of items for my district, District Number 5, for Derby, and a post-annexation hearing and a zone change. We have a grant policy change and a criminal justice report, a juvenile justice report, and some other regular items. And so it's going to be a fun day today. With that, I'd like to call the meeting to order. So I call the meeting to order for the Board of Sedgwick County Commissioners for Wednesday, June 1st, 2016. And with that, Madam Clerk, first item, please.
Invocation to be observed by a moment of silence. Please remain standing for the flag salute.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. All right. Madam Clerk, next item, please.
Roll call. Commissioner Unruh.
Present.
Commissioner Norton.
Present.
Commissioner Peterjohn.
Present.
Commissioner Ransaw.
Present.
Chairman Howell.
Present. Thank you. Madam Clerk, next item, please.
Public information announcements.
Good morning, Commissioners. Kate Flavin, Interim Public Information Officer. We have several items for you this morning, but first I would like to ask Holly Dyer to come up and talk to you about Clean Slate Day. You'll remember that we had this event back in March. So, Holly.
Thank you very much. My name's Holly Dyer. I am the current president of the Wichita Bar Association. At the beginning of March, District Attorney Mark Bennett and I appeared before you to talk about what was then the forthcoming Clean Slate Day, which was to be held Friday, March the 4th. Clean Slate was a project designed by the WBA in conjunction with a number of other entities, including the Sedgwick County District Attorney's Office, to provide low-income persons with a chance to expunge their criminal records. We envisioned this to be a one-day project. Anyone who was here at the courthouse on Friday, March the 4th knows that Clean Slate touched a nerve in our community. Although we were set to begin at 9 a.m., we had people lined up outside the courthouse as early as 6:30 in the morning. We had anticipated as many as 100 to 300, which we knew would be a challenge for us. What we did not anticipate was that we would have an estimated 1,000 individuals show up that day, most of which appeared before 9 a.m. Even though we had to turn away many people that day because we simply did not have the time or the resources to handle that many people in one day. I have to say that everyone who did appear, even though they had to go away, were patient, were kind, and were appreciative of the opportunity and of our willingness to volunteer to provide help. They displayed, I think, the best part of the Sedgwick County and the Wichita community that day. We were able, in a given day, in a single day, to expunge over 150 individual cases. That is half of what the City of Wichita and Sedgwick County had expunged in the entire year the previous year. We are still working with a number of individuals, about 100, who had been checked in that day, but we had not processed by the 5 o'clock at the end of that Friday. By the time we are done, I anticipate that we will expunge somewhere between 200 and 250 cases, and perhaps more than that once it's all said and done. At this time, we're not sure whether we will have another day like we did. It took a lot of resources and the cooperation of a lot of folks, including people here, that we're very appreciative of. But the WBA will plan to explore with its partners in this different avenues to fill this need in our community for low-cost expungement help. But my main purpose here today is to tell you, the Commission, just how thankful we are for the help and assistance that we had of Sedgwick County employees on March 4th and thereafter. The courthouse, if you were in the courthouse that day, you know it was a challenge, and we marshaled just about every person in the courthouse to help us manage those people that day. We had DAs, court clerks, DA staff, and courthouse security, which probably had the most taxing job of the day, trying to get that many people through security all at once. We could not have done this without all of their help and everyone in the building who had people wandering around waiting for their time to be called for their expungement. Without the patience and the professionalism of all these very valuable Sedgwick County employees, we could not have done this, and they made the day that much smoother. So I commend them to you for their professionalism, their helpfulness, and their positive attitude. I would like to take this opportunity to tell the audience who's listening or watching at home that there are ways that they can get expungement help if they need it. The forms for filing expungements are available online, both at the City of Wichita website and at the Sedgwick County website. They can go to the wichita.gov website and do a search for expungement. Is probably the easiest way to find the city forms. With respect to the county, they can go to the sedgwickcounty.org website and go to the district attorney's section and look for forms. Those can be filled out on one's own and filed on your own. For those who would like the assistance of an attorney and can't afford it, they can call the Wichita Bar Association's lawyer referral service at 316-263-2251, extension 103. For those who qualify for low-income services, they can contact Kansas Legal Services here in Wichita at 316-265-9681. Thank you again for your support of this project. I appreciate the time that you all gave to us in advance of Clean Slate Day, and I appreciate this opportunity to tell you how helpful and how proud you should be of all the Sedgwick County employees who are involved in this project. Thank you.
Well, Ms. Dyer, thank you for the great report. We love the program that has been so well received by the community, and for all the great work that the employees did, especially all the folks that organized this. And obviously some folks had donated their time and finances to make it happen. So thank you for all that. I think some commissioners have some comments or questions. So Commissioner Peterjohn?
Yes, thank you. I agree with your comments, Mr. Chairman, and thank you for coming down and providing this report. You said 200 to 250 cases. Can I assume that's 200 to 250 individuals? Or is it possible there's some people with more than one case and you had to do more than one for each individual?
It's
and
true.
So how many people are we actually talking about, would you estimate?
I estimate we will process, I believe, at least 250 people through the process. Now, some of those will not qualify. They may wash out completely. Some of those do have multiple cases. So a person might come in with 3 cases that can be expunged. So the numbers of cases expunged versus people are not going to match up. But in the end, we will have processed through our background check process at least 250 people, I believe.
Thank you.
Thank you, Commissioner. I don't see any other comments or questions. I just want to say again, thank you for all you do and for making this program work the way it does.
Thank you.
All right.
That is great news. Just a few more items, Commissioners. Tomorrow morning, there will be a ribbon cutting ceremony at a tag office, our new tag office at 2525 West Douglas. The ceremony will begin at 10 o'clock, and then it will be open for business starting Monday, June 6th at noon. And this location replaces our Murdoch tag office. Riverfest also starts this weekend, so be sure to get your buttons and participate in some of the fun activities. Sedgwick County will be represented in the parade Friday evening. And last week, the Reed family elephants of the Zambezi River Valley exhibit opened at the Sedgwick County Zoo. So if you have not had a chance to go out there, I highly recommend it. It's a great addition to the Sedgwick County Zoo. And finally, Commissioners, there will be a special commission meeting on Monday, June 13th at 6:30 at the Park City Hall. This will replace our regularly scheduled meeting on Wednesday, June 15th. So mark your calendars for Monday, June 13th. And that is all.
Well, Kate, thank you for all the information. There's a lot to take in, so just want to recap real quickly. The elephants are open. We have a meeting on Monday rather than Wednesday next week, so it's Monday evening in Park City. And I believe that's the 13th. Is that what you said? Okay. So anyway, there's a lot going on. So hopefully if anybody has any questions, give our office a call. We'd love to inform people on what's really going on around the county. So thank you for that. Madam Clerk, next item, please.
Public agenda.
All right. Do we have anybody signed up this morning? Okay, no one signed up. We will have a number of items this morning. We will recognize members of the audience that if they want to speak to the items, we'll certainly allow that to happen when we get to those agenda items. Next item, please.
Public hearing. Item A, post-annexation public hearing for the City of Derby annexation.
Good morning, Commissioners. Justin Wagner, Assistant County Counselor here. What's in front of you today is a post-annexation hearing regarding the service plan for properties that were annexed by the City of Derby in 2013. Referring to the map that's on the screen, if you look, there's a lighter tannish colored kind of square, rectangle I should say. Those are the properties that were annexed. There were 14 total parcels with 13 separate owners. They range in size from 4.5 to 7 acres. It's generally in the area described as being near the intersection, north of the intersection of Patriot Avenue and Woodlawn. The current city limits are indicated on the map in red, and again, these are residential properties, and one of the 14 tracts are vacant. I believe the other 13 all have houses in them. By statute, 3 years after any annexation, or after the type of annexation that occurred in this matter with a service plan, the Board of County Commissioners is required to review the service plan to determine whether the terms of the service plan have been met. The statutes require that the notice of this hearing be provided to the property owners whose properties were annexed. The notices were provided after your April 18th meeting in Derby. Furthermore, pre-hearing questionnaires were mailed out to all 13 of the landowners. Both the pre-hearing questionnaire and notice of hearing were also sent to the city. The only response that the county received to any of that was the City of Derby's response to the pre-hearing questionnaire. It is included in your backup materials. The service plan requirements that they included street maintenance, ditch cleaning, culvert cleaning, fire and police protection, city building code enforcement, city health code enforcement, minimum housing code and zoning enforcement, and installing new guardrails on a culvert. There are also a number of other items that the residents could petition for or request to receive. Again, I referenced the city service plan that was formulated back in 2013. It did substantially meet the requirements established by statute for what a service plan needs to include. It is worth noting as a bit of a historical matter. Back in 2011, the city initially contemplated annexing these properties. There were some concerns raised by the property owners. The city then worked with the property owners to address those through some zoning code and city code revisions. The city does have a couple representatives here today that could address any questions you may have on that, and also with regard to any of the service plan requirements and their obligation to meet those. Unless you have any questions for me, my recommendation would be that you open the public hearing. If you've had any ex parte communications, or if there's any additional information on this matter outside of the hearing process that you would like to consider as part of your determination, I'd suggest that you mention that at the start of the hearing so that if any of the parties wish to respond to that, they'd have the opportunity to do so. Then you would accept comments from the landowners and the city. And that's all I've got for now. Thank you.
All right, thank you for the report. I would just like to say so far that I had no ex parte communication on this. It was in my district, and no one approached me from the city or the residents that live there, so it's been a fairly quiet issue so far. I don't see any comments or questions from commissioners, and so with that, I'd like to go ahead and open up the public hearing, ask for anybody from the audience who would like to speak to this issue on the post-annexation public hearing of the City of Derby annexation. Anybody would like to speak to the issue? Now is your opportunity. All right. Seeing nobody interested in speaking at this time, I'd like to close the public hearing, and I'd like to ask the commissioners, what is the will of the commission? Commissioner Ransom.
Thank you, Mr. Chairman. I just want to publicly state that I had no ex parte communication from either the city or any constituents either. Thank you.
Thank you, Commissioner. Commissioner Peterson.
Thank you, Mr. Chairman. I'm going to basically, I had no ex parte communications with anyone on this issue, either with the city or residents in the affected area. Thank you.
All right. Commissioner Unruh.
Thank you, Mr. Chair. Just to repeat what's been said, I had no ex parte communication.
All right. Commissioner Norton.
I had no ex parte communication, and I'll move that we adopt the resolution authorizing the chairman to sign.
I would second that. However, I think
We did close the public hearing.
Okay.
Commissioner Unruh?
Thank you, Mr. Chair. I think that I would perhaps second the intent of the motion, but I think I'd just say that we want to make the finding that the City of Derby has provided services in accordance with the service plan. If that was your motion, Commissioner, that's what I want to say.
We have a motion and a second. Any further discussion? Commissioner Peterjohn?
Just a procedural motion. Are we still in the public hearing?
No, so we closed the public hearing already.
Sure.
Yeah, thank you.
Thank you.
So we opened and closed the public hearing. We didn't have anybody comment, and now we are on the motion. I would just want to say further, of course, just to let everyone know, I live walking distance from this neighborhood, and it is a very nice neighborhood. It is a quiet neighborhood. I actually know some people who live over there, and I anticipated somebody might contact me and give me some of their thoughts. And again, no one has commented, although they have had plenty of opportunity. I know we sent out the notices, and so we're doing exactly what we should be doing. And again, with the people don't speak up, I guess we have to assume that silence is consent. So with that, I see no further comments or questions from commissioners. We have a motion and a second. Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ranzau.
Aye.
Chairman Howell.
Aye. All right. Madam Clerk, next item, please.
Planning Department. Item B. Zone change from single-family residential to multifamily residential on property located approximately 1,800 feet west of South 143rd Street East along the south side of East Pawnee Road.
Dale Miller, planning staff. Morning, commissioners. This is a request, as she indicated, to go from single-family 20 zoning to multifamily 18, which means that they could have up to 18 dwelling units per acre, the MF18 district. What they're proposing to do on the application area here, it's outlined in the black tape on the south side of East Pawnee, about a half a mile west of 143rd, is to develop 39 units that would be mixed between 2-family, 3-family, and 4-family units. As you can see there, it is the south side of Pawnee is all in the county, as well as this property to the northeast that would be the northwest corner of 143rd and Pawnee. The area that's in white and the light blue is in the city of Wichita. Aerial showing the application area is nestled here between a couple of creeks. The area to the north is zoned to single-family 5 and is being developed as single-family residential uses. There's a golf course over here to the northwest with a clubhouse and a maintenance facility as well. 2 large lot residences over here to the northeast. Farm ground to the south. The applicants own the area from here to there, so it's all part of their ownership that the application area is on. Separate owner to the west. New residential is what the 2035 Wichita Future Growth Concept Map is recommending. This is looking south from Pawnee. There is as you can see, a significant hedgerow there that blocks the view of the application area from the street right away. Again, the hedgerow. And this is looking west. This is the subdivision that is developing to the north on the north side of Pawnee. The buildings way down here are the beginning of the golf course, maintenance shed, and clubhouse. Another shot of the developing subdivision to the north. The Planning Commission approved this unanimously, 11-0. It is recommended that you adopt the findings of the Metropolitan Area Planning Commission and approve the zone change. On page 2 of your alternatives, it indicates subject to plating, but that should be deleted. That was a typo. And so it is, we're suggesting that you recommend this approval without the requirement for plating. And there have been no protests. Try and answer questions if you have any.
All right. Just one question on the recommended action in front of me. It says approve the zone changes subject to MAPC approved conditions. Is that the plat language you're just referring to?
Yeah,
Okay.
I would delete the...
So I should delete that phrase from this recommended action?
Yes.
Okay. All right. Commissioners, do you have any questions or comments? All right. I'd like to ask the audience, is anybody here that would like to speak to this agenda item this morning? Okay, seeing no one. All right. This isn't my district. Again, this is progress, in my opinion. I'm anxious. I'm excited to see more housing available in my district, and I think this is a good thing overall. To the extent that we see some land being developed, I think that just shows the economy is beginning to thrive in other areas, and so I like the fact this is being proposed, and so I would like to make a motion for the recommended action to adopt the findings of the Metropolitan Area Planning Commission and authorize the chairman to sign the resolution and authorize the resolution to be published. Any other comments or questions from commissioners?
Second.
A motion and a second. Okay, I see no other comments or questions from commissioners. Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ransaw.
Aye.
Chairman Howell.
Aye. Thank you, Gail.
Thank you.
All right, Madam Clerk, next item, please.
New business. Item C, a resolution authorizing the transfer and use of monies from the Register of Deeds Technology Fund.
Good morning, Commissioners. Tanya Buckingham, Register Deeds for Sedgwick County. Chairman, in accordance with K.S.A. 28-115A, I have determined that the balance of the Register Deeds Technology Fund at the end of the 2015 calendar year is greater than $50,000 and that $500,000 is not needed by the Register Deeds Office for technology purposes. K.S.A. 28-115A thereby provides the Board with the authority to transfer those funds from the Register Deeds Fund to a county fund to be used by other county offices for equipment or technological services relating to the land or property records filed or maintained by the county. I recommend that you approve the resolution, and I'd be happy to answer any questions.
All right. First of all, I'd like to say this is, I believe, the first opportunity you've had to do this type of meeting agenda item. Is that correct?
Yes, it is.
I want to say thank you again for being our register, or our Register of Deeds. Tanya Buckingham was recently elected because of the passing of Bill Meek, and so I want to say thank you for being here and for the good report this morning. You did a great job. Commissioner Peterjohn?
Thank you.
Yes, since we're over 50,000, can you be a little bit more specific, Madam Register of Deeds, in terms of how much money is exactly going to be provided? Because this is one of the more fun events
Yes, it is.
from being up here on the commission bench when we're in this position.
Well, with the $500,000 that's going to be transferred that you'll approve today, we will be right over $5 million. And that started in 2002.
Wow, $5
Yes.
million total over all that period
Yes,
of time. Okay, thank you very much. That's
You're welcome.
I think an important figure, and I'm glad to be able to get it on the record this morning.
All right, thank you.
All right. Any other comments or questions from commissioners?
All right, thank you.
All right.
Mr. Chairman, motion we adopt the resolution, authorize the chairman to sign.
Second.
We have a motion and a second. And I don't perceive there's anybody here that wants to talk on this agenda item, I don't think. So anyway, so I will close the item. Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ransaw.
Aye.
Chairman Howell.
Aye. Commissioner Norton?
Just a reminder, this money doesn't go into the general fund. It goes into a technology fund for other land use areas like the appraiser and the county clerk. So it doesn't just go to offset other bills. It has to be used for technology that would affect land use. Is that correct?
And she says that's correct. All right. Thank you for that clarification and that reminder, Commissioner Norton. Madam Clerk, next item, please.
Item D, amendment to extend existing grant from the Kansas Department of Health and Environment in the amount of $915,295 to provide outreach, prevention, and intervention services through the Health Department's Healthy Babies Program and the Healthy Families American Program at the Kansas Children's Service League.
Good morning, Commissioners and Board of Health. Adrienne Brunlitz, Sedgwick County Health Department Director. This morning I'm asking for your consideration of the grant award in the amount of $915,295 from the Kansas Department of Health and Environment to provide services to at-risk pregnant women, children, and families through the Health Department's Healthy Babies Program and the Healthy Families American Program at the Kansas Children's Service League. Approximately $745,000 of that would stay with the Health Department and the Healthy Babies Program, and then $170,000 of that passes through to the Kansas Children's Service League. We've received this funding for 14 years. This agreement for the Health Department pays for part or all of 10 positions and then contractuals and commodities. Healthy Babies is an educational program for prenatal and parenting families. Education and family support is provided through home and office visits. Services are available to all Sedgwick County residents regardless of income or insurance coverage. Program outcomes focus on decreasing the number of preterm and low birth weight babies to Healthy Babies participants, as well as increasing safe sleep practices of putting the baby in the bed on its back, and if there are any blankets or pillows, toys in the crib with the baby, to make sure that all of that is removed so that it's a safe sleep environment. In 2015, Healthy Babies provided services to 775 women and 602 babies. I recommend you accept the award, authorize the chairman to sign the grant award amendment, and authorize the purchasing director to provide written notice to the Kansas Children's Service League of the county's intent to exercise the third of the 3 one-year options to renew this grant. I'll be happy to answer any questions.
All right, thank you, Director Brunlitz. Is there anybody from the audience who would like to speak on this agenda item? Seeing none, Commissioners, is there anybody here that would like to? Commissioner Peter John.
Yes, thank you, Adrian. It's been a while since we've had an update on the number of SIDS cases in our community. Can you give us any sort of a ballpark in terms of how we are doing county-wide on those cases? It's because I was thinking it was about this time last year we had an approval and had some discussion on SIDS at that time, and I know we've talked about it a number of points, and the idea of trying to get people to have the baby sleep on their back instead of on their stomachs has been a continuing challenge.
I do have Candace Johnson with me. She's the Healthy Babies Program Manager. Do you have information on SIDS?
Please come to the podium, please. Thank you.
I am only familiar with the most recent ones that have occurred in 2016. I don't off the top of my head have the 2015 numbers. We do partner very closely with the Kids Network, and their primary focus is adding that additional education for safe sleep.
Okay, thanks. In 2016, we know we have at least 7 already that have been identified as co-sleeping deaths. I don't know if those have been confirmed through autopsy, but there were 7 reported deaths so far.
Could you, when you say co-sleeping, or what are we talking about exactly?
Sleeping in the same bed with mom.
So we've had 7 cases. Is that statewide or local? Countywide?
I believe it's local.
County numbers?
And I'll confirm that for you.
Okay, because I was going to say that's continuing. It sounds like a continuing educational challenge, because
Absolutely.
Most of the SIDS cases previously had been the infant was sleeping alone on their stomach as opposed to sleeping with anyone else.
Yes, it is a challenge. There are lots of families and women that co-sleep where the baby's safe, but it is a risk that really isn't worth taking. Moms are tired and they're breastfeeding, and so to ease that transition, lots of moms go ahead and make that choice. And again, there are plenty of cases that there are plenty of instances that don't become cases, but it's just not worth the risk to co-sleep.
Thank you.
Along that questioning, I believe I heard you say, or someone say, that one of the cases was in fact a Healthy Babies client, I'm not sure what the right word is, but someone that is involved in the program, they also had, I guess, one of these SIDS cases was related to the program.
I believe that is true.
That's correct.
Yes.
So the other 6, again, apparently were people that we didn't actually provide services to. So again, one of my, I'll just go ahead and say what I said last year. One of my concerns about this program, and I think it's a good idea, it's a good program, and I certainly appreciate the intent of the program. But by my calculations, we're only touching about 1/32 of the population that actually is having children. They're identified as higher risk people, but there's a lot of folks out there that are having these same issues that are not in that high risk pool. And so somehow it would be my wish that we could somehow expand this program. I believe we're spending a lot of effort on a few people. I'd like to see lesser effort on a much larger audience, and so that we have hopefully some effective outcome that would be much broader than just 1/32 of the population. So again, it's just my opinion. I know this is a program that's designed by someone at the state level, I assume. Who is this program?
This is federal pass-through.
Okay, so this money is intended to be utilized exactly as we're utilizing the money. So
that is correct. We
don't have the freedom to re-engineer this program, but if we did have that freedom, again, my opinion is to have communication to the majority of moms would be my hope, and unfortunately, that's not the way the program is designed to be utilized. And so, so out of these 7, it sounds like 6 of them were folks we didn't have any communication with. That's unfortunate, and one that we did. And I know that looking at the statistics for the folks in the program, it has been effective for them. It's not very often that someone in the program actually has a SIDS event, and that's extremely unfortunate that happened here in 2016. But I guess my wish would be is that the program could be expanded so that many more moms would have the information. Maybe not as many visits, but have some input from the program, and that's not the way the program is designed to be implemented. So that's unfortunate. Commissioners, any other comments? Commissioner Norton.
Well, I think you're right, but there is a system out there between the SIDS network, Safe Sleep, the hospitals, places where people get prenatal care. This is just a sliver of the whole system that talks about infants and how they sleep, how you keep them healthy, how you keep them safe. So even though we'd like to maybe reach more people, I really believe there are plenty of fingers out in the community that try to reach the total population, and then we really zero in on those at most risk. But between Kansas Children's Service League and Safe Sleep Coalition and the SIDS Network, I think there's plenty of information out there for the general population, and then we're really focusing on that really hardest to get to population.
All right, thank you, Commissioner Norton. Any other comments from commissioners? All right. What's the will of the board?
Mr. Chairman, I move that we take the recommended action.
Second.
All right, we have a motion and a second. Any other comments? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ranzau.
Aye.
Chairman Howell.
Aye.
Thank you.
All right. Madam Clerk, next item, please.
Item E, a resolution to revise the Sedgwick County grant application and award policy.
Good morning, Commissioners. Justin Wagner, Assistant County Counselor, again here to present on a proposed modification to the county's grant application and award policy. Just to kind of go back to how this document was initially put together. It was initially established in 2008, and then it was amended most recently in 2013. It really outlines what grants the county, maybe not what grants, but kind of the scope of the county's grant participation. It also delegates some authority to the county manager to approve grants in terms of based on dollar amounts, match requirements, whether the grants do or do not add FTEs. And it also lays out the procedure so that staff can look to the document and understands how to process those grants through our Legistar software and some of those features. This item that's up here today is the grant, proposed grant modifications. Really, the key change to it would be to have the county not accept certain grants, HUD grants, that fit within the affirmatively furthering fair housing regulations. And in the draft that was in front of you, the red line draft, and there's also I believe a clean version of it, it'd be subsection 4G of the grant policies and procedures. Commissioners Ranzau and Peterjohn had requested this item, I think in an attempt to be, what they had indicated was to be proactive and not have the county enter into grants that are subject to these affirmatively furthering fair housing regulations. And I'll get into a little bit more detail here as to what those regulations include. But really, that's the gist of what the modification would include. These, I'll just call them AFFH regulations. They are new HUD regulations that were promulgated last year. The stated purpose for them was to expand upon the Fair Housing Act statute, which was enacted back in 1968. And it directs all executive departments and agencies to affirmatively further the purposes of the Fair Housing Act. The scope of these regulations, I mentioned earlier that they apply to HUD grants, certain programs within HUD. And in particular, on this slide, you'll see the different programs. It's Community Block Development Grant or Community Development Block Grants, Home Investment Partnerships, which I understand those are for repairs to dilapidated housing. It's a grant program for that. Emergency Solutions Grants, Housing Opportunities for Persons with AIDS, and then also Section 8 and 9 housing, which those are both housing voucher types of programs. The only program out of those 6 that the county currently participates in is Section 8 housing. The revision to the grant policies and procedures that's been drafted and is in front of you today would prevent the county from participating in the first 4 programs that were mentioned, and they're listed on the slide there, outright. In other words, and those are the 4 that are mentioned chiefly in the material from HUD, some of the commentary, and essentially the county would continue, if you all adopted this policy, would continue to not apply for those grants or enter into grant agreements for those. The revision to the grant policy would apply to Section 8 and 9 housing at whatever point HUD would require the county to complete an assessment of fair housing as part of its application and agreement process. The timeline included within the regulations, of course, it's not as explicit as just saying Sedgwick County is required to do it on this date. It's based. There's different time frames for different how you're classified as a housing authority. As best I could tell, and how we're classified now, assuming that would still be the case into the future, it would be January 1st of 2020 is when the county would be required to have an assessment of fair housing completed for our Section 8 program. And really to kind of give an idea of the scope of that, just so that it's understood, the impact if you pass this is that there are 167 current Section 8 housing contracts, and I understand the county's authorized to have up to 342 total. If the county were to approve these grant policies changes, at whatever point HUD would require that assessment of fair housing, the county would not participate in Section 8 housing agreements any further. It's important to note that there are 2 pretty vastly different lenses. I think that you could view some of the positions on HUD and these affirmatively furthering fair housing regulations. It's also worth pointing out, as noted on the slide here, that these regulations have been the subject of some scrutiny in Congress. In particular, actually, about 2 weeks ago, the Senate actually just voted to, for lack of a better term, defund these particular provisions and the HUD's enforcement of these regulations. It failed 37 or 60 to 37. There was also a similar vote last summer by the House of Representatives that initially passed, but then it didn't go any further. I believe it ended up not making it further as part of the omnibus bill at the end of 2015. And really, as I mentioned, that this can be viewed, I think, through 2 distinct lenses. The first would be the position that HUD's put forth in promulgating these regulations. They indicated the regulations give the grant recipients clear guidelines. They also provide quite a bit of data so that their housing operations can further fair housing. The claim that HUD has made is that this allows grant recipients to address housing disparities. They also say that I think they have some, in their commentary, some recognition that the term affirmatively furthering fair housing is very vague, and so that they wanted to provide some clarity to the grant recipients. And then also that they have a duty to do this under the Fair Housing Act statute, and that they're following their charge, that's been through the Fair Housing Act to do this. The opponents of the affirmatively furthering fair housing regulations, broadly stated, have viewed this as an intrusion into the local government that amounts to, by the federal government, that amounts to overreach. And really, there's a whole host of claims have been made, and some of those are that the regulations that are proposed exceed the scope of the Fair Housing Act, because it gets into things such as items that are conceivably viewed as non-housing elements, such as transportation, planning and zoning, employment determinations. There's also been claims by some of the opponents that these regulations are overly burdensome or amount to what's been referred to as social engineering. Also, some of the claims indicated that some of the concerns, I think, where this would lead to increased enforcement by HUD in terms of following the grant recipients to making the grant recipients follow the regulations and possibly pursuing legal action if they didn't. And really, the claim there is that the grant recipients, as part of this assessment of fair housing, may kind of build a case against them by noting all the things in the community that are not supportive of the Fair Housing Act. And then if through their grant receipt they fail to adequately address those, they may get sued. And there's a case out of Westchester County, New York, that's viewed as kind of the cautionary tale if you're an opponent. Just briefly speaking on that, I mean, it's the most extreme case that we can see. But the concern is, in that case, the county in Westchester County, New York, the position was that they accepted some of this HUD funding. The claim was that they did not adequately address their housing disparities and actually exacerbated the housing disparities with where they were locating some of the housing they provided. And ultimately, there was a lawsuit, there was a settlement agreement reached. Then years later, the same plaintiffs from the earlier case came forward and said that they failed to meet up to the obligations of their settlement agreement, which were pretty extensive. I mean, as part of the settlement agreement they reached, they were supposed to take any and all measures to affirmatively further fair housing, and really the court found that they didn't meet up to the terms of that settlement agreement. The concern from the opponents of these affirmatively furthering fair housing regulations is that lawsuits like that may become more prevalent. Moving on to the conclusion here, it's very important for me to stress, I'm an attorney. Both myself and other attorneys in the county counselor's office, we will often tell you what the law requires. We will often tell you recommendations on the law. This item isn't really one that is a legal required action. It's squarely a policy decision for you all to make. It's up to the will of the board as to what you'd like to do as a policy decision. In my opinion, this is not a significant liability concern. First, for a couple of reasons, it's unclear how HUD is going to utilize these regulations into the future. And then secondly, it's somewhat, when I say it's not a major liability concern, that's kind of specific to Sedgwick County. And that's assuming our current participation, which is just Section 8 housing. These are smaller contracts, kind of disparately located in different places around the unincorporated area and in second and third class cities. So I think that where you would see a higher likelihood of liability concern would be, for example, if we were taking several millions of dollars in a community development block grant or something along those lines. But really, as I noted, it is a policy decision. I noted I think that really Commissioners Ranzau and Peter John are certainly, I think we'll speak to this, but the concern from their standpoint was trying to maybe get ahead of this some is what they're hoping to do. The recommendation that I would have is just take whatever action you all as a board deem appropriate, and I'd be happy to stand for any questions on this as well.
Thank you for the good report this morning. Commissioner Ranzau.
Thank you, Mr. Chairman. like to make a motion that we adopt the revision to the Sedgwick County Grant Application and Award Policy as we were told that this is an attempt to be proactive and stop the federal government from intrusion into our local affairs. This is clearly an attempt on behalf of the federal government to exceed their constitutional authority with respect to local planning and housing decisions. And while right now we've not participated in a lot of these programs a whole lot, I think it's in our best interest to avoid doing so in the future. We don't need the federal government intruding in our local affairs any more than what they already do, and this is how they try to control us. They give you some money, then they want to tell you how to live and where you have to build a house and what you have to build it and what you have to eat and what you have to drink. And quite frankly, I think the people of Sedgwick County and the state of Kansas are just fed up with it. So we're going to stand up and say enough is enough, and rather than intruding into things that for which the federal government has no constitutional authority, won't you do something about things that you do have authority in? But of course, that's not the situation we're at right now. So I appreciate the work that the counselor's office has done on this, and I fully support this change today.
All right. Commissioner Peterson.
I'll second the motion, and I've got other comments at the appropriate time, but I'll just leave it at the second for the moment.
Okay. Any other comments? Commissioner Unruh.
Thank you, Mr. Chairman. I'm in harmony with the position that we don't want any more intrusion from the federal government. I think I've said pretty strongly about I don't like intrusion in my decisions from the state government, and I also don't like them from the federal government. I'm just wondering, in my consideration of this, I mean, it doesn't seem like it hurts us in any way. But do we not have the ability to turn down these grants anyway? The way that our current policy is, anything over $25,000, it's the Board of County Commissioners that has to make that decision to receive a grant?
And Marty Hughes is here, and he may answer if he needs to correct me on this, but my understanding is on the Section 8 grant, we don't have like an annual grant that we get, like a chunk of money that comes for approval. These are individual contracts that or agreements that we have with the tenant, or I'm sorry, the landlords, and then we also we're kind of have an agreement with the tenants as well. They have to follow the program requirements, and so those individual agreements, I don't believe come in front of you in that context. However, what this grant policy would do is, if you all approve it, is this would cause, once HUD requires that assessment of fair housing to be completed, which we think again is going to be in 2020, we would no longer apply for that unless and until the county commission would amend that policy at that point. And so we aren't at this point. We aren't required to run a major grant that's in excess of $25,000 in front of the Board of County Commissioners. Instead, there are individual grants that come up for approval with the tenants and the landlords.
But do we not, I understand what you said, but we do not have to approve application for this?
There's no, like a lot of the grant programs that we have, they have annual applications. But Section 8 housing, there's not actually an application. And I think Marty Hughes is going to come up and maybe address some of that a little bit more specifically.
Good morning, Commissioners. Marty Hughes, Revenue Manager with Finance. On the Section 8 program, the funding is an annual allocation from the federal government, from HUD, and so we don't really apply for it each year. It's just basically allocated to us, and we have it available to use for these vouchers for rental assistance. So in that respect, we don't really go through an application process. In general, on the current grant policy is that if a grant is $100,000 or more, it would come before the commission, before the board, to be approved. Anything less than $100,000 of course, would be under the county manager's approval process. So in that regard, under normal circumstances, a grant would, over $100,000 would come to the board for your approval before we accept it, or even apply for it, for that matter. But in this case, for the HUD voucher program, it's just basically an allocation of funds, and it doesn't really go through an application process. So I don't know if that answers your questions or makes it clear.
That's helpful. I appreciate that, Marty. So, okay. I guess the question is, how would this work then? If in 2020 it's a potential that they may put this AFFH, apply it to Section 8 housing, so that would just trigger that we would send them a note saying don't send us any money? Is that the...
And that's a good question, Commissioner Henry. There's a couple of different thoughts that I have on that. First, the way that the language in the regulations is worded is it says for a qualified housing authority, which is what Sedgwick County is classified as now, after the last year of the current 5-year plan, which our current 5-year plan ends at it ends December 31st, 2019. After that, we would be required to do follow these regulations for Section 8 housing. And in pointing that out, the thing to know is I would imagine the way HUD is going to do this, and it's worth noting that some of our staff's had some communications with HUD, and they haven't, I don't think, been especially enlightening in terms of helping staff understand how HUD is going to apply this to Sedgwick County. But I think the way it would probably apply is they would include it in that 5-year plan. That language, it's addressed as a certification that the county would affirmatively further fair housing in our 5-year housing plan that was approved in 2015, but there's not the assessment of fair housing that's required. That would apply likely as part of our 5-year plan then if the current regulations stay in place and as we're understanding them. Again, we still have sought some feedback from HUD on that, but that's how I believe it would occur. But you asked about how the existing housing would be required. And there are due process rights attached to probably both the landlords and the tenants and their agreements they have with the county, and that's something that would have to be addressed into the future if this policy is passed. But there's certainly some time to do that between now and then. But there are some due process rights, so it'd probably be more than just sending a letter. And there, it's probably one of those things where providing as much notice as possible would be advisable as well. But.
Okay. Well, I just, like I say, I'm in harmony with this. I think the federal government in this thing had deplorable overreach, especially in the example we have from that case in, I believe it's in New York State. I just don't want to be tying our hands if there is something about this AFFH that we can live with, that's workable, and we can still provide this housing for some of our citizens in the future. Because I don't know what the regulations are as they apply to Section 8 because they haven't been determined yet. Is that right?
Well, I guess, and maybe I should have explained this in a little bit more detail. What the regulations require if you're a grant recipient to do is you do the assessment of fair housing is where you analyze all this data from various things, whether it's jobs, whether it's demographics, all these different factors, and you try to find areas that your community does not has disparities in housing, fair housing. And you try to identify those, and there's a public hearing process. It's not just like a one-page document. It's a very involved process that would have to be undertaken, and a lot of analysis of data that's taken so that when you apply for the grants that are subject to those regulations, you are indicating what the disparities are and how you're going to address them. And the concern, again, is that I think from some of the opponents of this is that you take the funding in this and that maybe things don't go as you planned in that assessment of fair housing, and then that you may be subject to either HUD trying to file suit or a clawback for funds or something along those lines. I think that's the concern that's expressed. But that's really, the assessment involves a lot of analysis, involves some public hearing process, and then it's really kind of tying all that together and pointing out where your disparities exist And there's some mention of taking it into consideration in your planning and zoning, and some of the other community transportation, I believe, was mentioned as well. Some of those types of things that you do in local government. Does that help answer your question, Commissioner?
I think so.
Okay.
I'm not sure what my question was, if you want to know the truth. It's, I guess I'm just thinking about making a passing here resolution about a potential move by the federal government, which we will not like, but we don't know what that is yet. We're just thinking it might apply in 2020, and it just, and I understand preemptive action. I understand that that's legitimate, but are we presently in a situation where we think we might be in violation?
No. Well, we haven't been required to. We haven't had any claims along. We haven't had any claims that we're in lack of compliance. That's part of our status as being a qualified housing authority. Is I think you have to have less than 500 total grant agreement or total agreements. We certainly have less than that, and you also can't be in. I forget what HUD calls it, but essentially in the warning status where you've had concerns and problems raised. So.
Okay, well, if I noticed Annette Graham's here, and it's her department that runs our housing program, and she hasn't jumped up to say anything's wrong in what's been said, so I won't pick on you, Annette. But I guess if we're doing a good job now, we don't know what those regulations might be. They haven't applied them to us yet. If they do what we think, I mean, it's a good thing what we're contemplating here, but I mean, it seemed like I would prefer that we make our policy when we know what more of these details are, what might happen. But I agree, it looks like they're heading down that road of being able to put restrictions on us and requirements on us that we will not like. So I understand all that. It's just, I guess my initial thought is that we could wear our law department out trying to make resolutions about things we think might happen that we won't like, and when we don't know exactly what they are yet. And I know that, as has been said by Commissioner Ranzau, you put a lot of work in on this. So I don't know. I guess I'm not opposed to the intent of this thing. I'm in harmony with it. It just seems like this particular preemptive action is we're being too aggressive on our side, it seems like. But anyway, that's all I had.
Thank you, Commissioner Unruh. If you don't mind, I'd like to give the public an opportunity to speak to this agenda item. Does anybody from the audience that's here would like to provide any comments regarding this agenda item this morning? All right, seeing none. Commissioner Peterjohn.
Well, thank you, Mr. Chairman. I agree with Commissioner Unruh in terms of we've got examples nationally and in other parts of the country, which I think he called it a deplorable overreach. And unfortunately, I think that's not a rare example. It's increasingly a commonplace event, and that's the reason why I was supportive. I want to try and provide some information for the record, because I do think it's important for us to be proactive instead of reactive, because we have a policy in place where we've got appointed county staff. They're involved in grants, and especially with the description on how Section 8's handled, but also if we've got grants, I believe it's $50,000 and less, that can be approved without actually having to come to the commission. And so we need to set policy. And so I'm supportive of the of this proposal, which is why I seconded it. I appreciate Commissioner Ranzau's work on this area. I want to provide just a little bit of background, because this is a variation on some previous discussions we've had where Washington's all too happy to, put a little money out in a grant and then have all sorts of hooks in terms of regulations, rules, and whether it's affecting planning, housing, zoning, or what we might generally call social engineering, putting more provisions in place to come at us. And I think this is important for some other reasons. I think will be a benefit to other local units that might be following what direction we are proceeding here with Sedgwick County. I've had cases where at K.S.A. events, I've had other commissioners come up to me and ask me about what we did and why we did it at the county commission level here. And I think it's important because we there are other local units that are going to be affected by this, and if mandates, edicts, whatever you want to call it, no law has been changed from Washington. This is an interpretation that has come down, and it's often unclear, but I'm going to assume that it's coming out of the bureaucracy in one form or another. We can talk about motivations and the people who are administering current federal statutes, but in the rather challenging environment that we live in at the moment, I think it's important for us to be out front and to give guidance, because if staff ends up in a situation where there's grants and the commission's in a position where we aren't meeting for a while and action needs to be taken, I'd like to have our policy set in place so that we're going to be determining the policy. There's a lot of talk about local control. I think the closer we can bring it back to the people and is a better step, and I think certainly at the local level we're a better determinant than what Washington may want to do in terms of their edicts coming out of our capital. So I will be supporting of this proposal today, and I really hope that this won't be necessary in terms of in the near future, but like I've said in other contexts, the old Boy Scout in me, a Boy Scout motto is be prepared, and I view this as a step in being prepared. Thank you.
Thank you, Commissioner Peter John. Commissioner Ranzau?
Thank you. Yeah, just to clarify, we do know what the feds will require. They will require a furthering fair housing assessment. That means we would participate and pay for and fund an extensive assessment. A lot of people would be involved in it, and people would have could say they think this or that is unfair practice, and you have to come up with a plan to address that. And if you don't do that satisfactorily, correct me if I'm wrong, Justin, but some of the people actually participate in that assessment could then sue the county. Or who could sue us?
You know, it's a good question. Standing's really the issue, and I believe sometimes you have, for lack of a better term, maybe interest or advocacy groups who may come forward and bring suits. So I think that could be a possibility. I don't think that necessarily just the participants in the process of developing that would have standing to sue. And then certainly, there's a possibility that HUD, the federal government through HUD could sue you and say you're not following the regulations that are in place.
We'd had a discussion in my office. Maybe it was the advocacy groups, or
the advocacy. And I think there was an advocacy group involved in the Westchester County case. I think they were the plaintiff, the chief plaintiff. I think the United States was also one of the plaintiffs, but I believe that they. It wasn't just the United States. I think there were a couple other parties that were involved, and I don't know if any individuals as well. But when you asked about the question about the participation in developing the assessment, I don't think if you're just somebody who participates in that you'd have standing. If you're just somebody who gets up and speaks, I don't think you have a standing in a future lawsuit. I think anyone who may, it's tough to predict how all this would work out. But if you're somebody who says that you were harmed because you didn't get your housing was located in an area, in a economically disadvantaged area, and that was not compliant with fair housing, then maybe that person would have standing too. I'm not certain on that, but those are probably the more likely plaintiffs in those types of situations.
Okay. Nevertheless, we'll open ourselves up to litigation, and it's about controlling people saying, well, this type of housing needs to go here or there or there, and you enforcing us to use zoning and planning regulations to do that, rather than allow a market-driven type of solution to whatever the housing market desires. So it's a form of centralized government planning that they're trying to exert upon us in their vision and control us and push us into do it, because either we'll get sued or we'll lose funding. So I think now, when we're not taking a lot of that funding, is the best time to say we're not going to participate this in the future. So if they make the decision to try and force us to do it, that ultimately will be their decision, but we'll be prepared to address that and to avoid those undesirable consequences of the federal government's action. Thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner Norton?
I'm probably not going to support this today. I understand what we feel about the overreach of the federal government or the state government. I think this right now has much to do about nothing. We don't participate much in housing. That's more municipalities and other governments than us. In fact, over the years that I've been here, we've diminished what we've done on housing and our partnerships with HUD. So I think having this conversation is healthy, because that does kind of raise the red flag that maybe in the future we'll need to do something. But to eliminate our flexibility, not knowing exactly what's going to happen, I don't think I can support that today. Although the conversation is good, because now we understand what may happen in the future. 2020 is pretty far on the horizon, and as I see it, we've continued to diminish our footprint as far as any kind of housing, and that falls more towards many of the other programs that were defined here that we don't participate in and never have. So I'm not going to be supportive of this action today at all. That's all I have, Mr. Chair.
Thank you, Commissioner. I have a couple of questions. I'm looking at the actual policy proposal on page 3 of 5 on item number G1. It says requires an assessment of fair housing and/or.
Correct.
I think we need to make that and/or an or. I mean, it needs to be one or the other, because to me, and and or together does not create clarity.
I think it could just be an or. I think
it needs to just be an or. Okay. Because again, let me go back a couple of pages in the backup material on page number 3. Excuse me, page number 2 of the backup material. Reading top paragraph, it says that the proposed revision to the grant application and award policy were to be adopted, and if HUD were to begin requiring the AFFH assessment as a condition of the county receipt of Section 8 funding, and absent any subsequent modification, then we would be prohibited from applying for these funds. And so the word there in that paragraph is the word and. So I'd like to just be clear, which is it?
Well, and let me kind of explain the thought behind how this is drafted, since you brought it up. It indicates that if you look under G2, that specifically identifies, if you refer to the regs 24, which are referenced about midway through there, 24 CFR 5154B1, those are those 4 programs included in there. And so those specifically, it specifically encompasses those. I think there was some concern as to if future programs were brought into the affirmatively furthering fair housing regulations. And so one is a catch-all. G1 is intended to be a catch-all that would include, at any point in time when Section 8 and 9 housing is required to complete the affirmatively furthering fair housing's assessment of fair housing, or any other program that may follow into those regulations in the future. It's intended to be a bit of a catch-all. So there is some overlap between G1 and G2, but that's intentional so as to be as broad as possible. And to also give some specificity to staff on G2 as to what regs we're referring to.
So just from my question, would it be troublesome to change that word to the word or to make it clear?
I think or would probably make it clear up any confusion on that.
Do I need to make a motion to make that change, or?
If you made your motion, you said subject to the change
Okay.
deletion of and.
I'd like to do a red line change to that phrase and remove the word and, so it's clear. And just to be for further questioning here, under G2 A through D, have we received any of those types of funds in the past? Or can you speak to that?
Yes, we have. I know we've participated, and if you have further questions, Marty's going to be better able to answer those, but I know we've participated in the home investment partnerships as recently as I think roughly 3 years ago. We had participated in that. I don't believe we've ever participated in the community development block grants, as far as I know.
Yeah.
Oh, we did? Okay. I'm going to cede to Marty Hughes to answer your question.
So as you answer this question, please talk about the magnitude of the grant and about how long ago it was.
Okay.
Please.
Okay. Actually, I went over, did a little history study on this recently in lieu of this item, and so what I found was dating back to 1991, we received the following number of grants in different categories. Under the CDBG category, we received 8 grants totaling about $1,644,000, and they cover. There was a Wichita Heights water project that we did, a 1993 Road and Bridge urgent need grant related to some flooding that happened back then. And then we had some CDBG housing rehabilitation grants, and we had a Sunview sewer urgent need grant where we had a sewer problem from a flood back in '97, I think it was. And then we had a economic development grant, United Warehouse grant in 2003. So those are the primary, and then of course we have the microloan, the CDBG microloan program too. So those are the primary projects that we had under the CDBG program, and then under the home program, we've had multiple housing, either rental assistance or housing rehabilitation programs from 93 through I think 2010 was the last award we received on the home program. We had 16 of those, totaling about $2,426,000. And then there was one other program that's not mentioned in the regs or in the Federal Register, and that's the Neighborhood Stabilization Program, which we just completed a couple years ago. And it had a requirement for this particular requirement, federal requirement, and it was just one grant for about $5,600,000. So that's kind of a summary of what we've had in the past. And in the past, there was affirmatively furthering fair housing requirements, but it was more of a passive requirement in that we did just basically outreach, notifying, making brochures available, or through fairs or a senior expo, things like that. So there wasn't really any planning related to it or anything like that. So
just to confirm, how long ago was the stabilization program? You mentioned a stabilization program.
Stabilization program began in 2009, and it wrapped up. I think our last expenditures were in 2013 on that grant.
And was there a assessment done at that time for that?
No, the assessment wasn't required. But the requirement was more of a passive notification, just making it available through brochures or bulletin board posters. Then we had, I think we had some proclamations that we did in April for Fair Housing Month, just to make it, public, know that there is a, fair housing laws, basically.
Okay. So. Thank you for your answers. Mr. Wagner, one more question for you. Just to confirm, again, if we adopt this policy change today, there's nothing in this policy that prohibits us from visiting this in the future. Say we decide we want to go ahead and do the assessment, it should be required by the government. We would do the assessment, and we'd be able to receive these block grants at that time. We could do that at any time.
Correct. You could amend them at any time with a simple majority vote.
Right. Okay. So it just takes a simple majority to reverse direction. Okay. Thank you for your answer.
Thanks.
I have some further comments, but all this, I'll recognize Commissioner Ranzoff first. Thank you.
Thank you, Mr. Chairman. Yeah, just to clarify some of the history and how we got here. When we first found out about this, one of the first things I did, I asked if we were participating in any of these programs, and staff said no, but we had in the past. And with the exception of Section 8, which we're still doing, but some of the 4 that are the primary programs at issue here, we're not currently participating. So it really made sense. And keep in mind, in the past, this new rule was passed in 2015, correct? So in the past, although there was a fair housing requirement, it wasn't as specific as what it is now. So moving forward, participating in those same grants could trigger additional requirements and much more specific requirements. So it just makes sense now at a time when we're not receiving those particular grants to go ahead and put this in our policy so that we don't inadvertently or unaware, whether staff or the commission, we apply for and get ourselves and involve something not fully understanding the additional requirements that would now be required. And so that's the rationale behind this. And we did identify specific ones in here, but then that first number one there, as previously discussed, is a catch-all in the event that the federal government decides to make this assessment a requirement of some other program that's currently not required, so that the staff will be aware as they go through and apply for grants to ask that question and to ensure that we're not inadvertently getting into something that would trigger this requirement. So.
All right, thank you, Commissioner. Just a couple of comments here. I was in the legislature in 2011 when the Kansas Department of Education made a choice to move into Common Core, and this was done, I would say, for the most part, without the knowledge or the consent of the Kansas State Legislature, and they've spent a number of years trying to repeal the move towards Common Core in the state of Kansas. And had they had something like this in place, then that would have had to go to the legislature for approval in the first place to move in that direction. But they didn't have that type of stopgap policy in place, and therefore the agency on their own made a decision to go in that direction. And the legislature has spent a number of years and tremendous number of hours debating whether this is the right direction for the state of Kansas. And it's been very controversial and very political. And I see this as not a limitation on our ability to move in this direction, but what this is allows us to make a thoughtful, conscientious decision to move in this direction, should that be what comes at us. Obviously, this is political. On page 2 of the backup material, it says that the AFFH regulations have come under some scrutiny and have been votes within both U.S. House of Representatives and the Senate to not apply for or enforce the regulations. This is, the Congress has spoken to this to some degree. They don't have control over the agency of HUD, and so HUD's making rules on their own without necessarily the consent of Congress. And so I see this as a very similar situation. And I think that what this does today is allows us to make a thoughtful decision, should this be the way that the agency begins to mandate what we have to do here. Again, we can always go that direction if we want to, but it gives us a stopgap in place to make that decision thoughtfully, and rather than just assuming that it'll be done by agency decisions. And so I think that the Commission needs to be involved in this, and I'd like to support the resolution today. And on that note, let me just say, the government does have many examples of ways that they control local decisions with money. Most recently, we have the president who's spoken to the restroom policies of our local schools. Is a good example, and I think there's many who are concerned that might involve federal funding for our schools, and therefore there's a great interest in whether or not we need to amend our policies based on that alone. That's a good example. It's very recent, but having an addiction to other people's money make decisions that are not really local decisions, but decisions because we're simply attached to these grants and can't make thoughtful decisions when these things happen. To me, I think that this is a timely decision today to amend this policy so that when this comes at us, and if it comes at us, we will have the chance to have a much more robust debate at that time and make a choice whether we should go down this path or not. Commissioner Unruh?
Thank you, Mr. Chairman. I guess want to reiterate what was confirmed, that our program now is fully in compliance, and this is not an action to try to protect something that's where we feel like we're not up to speed on any of our housing programs. Is that?
I mean, I would. To the question, I mean, yes, I'm not aware of any claims or any action by HUD against the county for any of our housing authorities or anything along those lines. This is I think the word proactive has been used, was the intent behind it was to make it very clear that the county is not going to participate in this if it were passed, in these types of programs that were passed. It's not as a result of any claims from HUD that we're failing to affirmatively further fair housing or anything along those lines.
And that and this action is on the basis of what we've seen in other places we think might apply here.
I think that's some of the concern. I mean, there's a number of other concerns, but I think that the potential for for some lawsuit or something like that is part of the concern.
Okay. That's all.
All right. Well, we're going to vote in just a moment. My final comment would be, again, I believe our folks that administer this program right now are doing a great job, and so this is not in any way criticism to them. I think we're doing a good job, and I believe that we're, in the absence of any current lawsuits or criticisms from anybody, I think that's evidence right there that we're doing it right. And once you get into this assessment, I think it just opens us up to a lot of criticism that we don't currently have. And so the idea of fairness is a theoretical idea, but it does open up the idea of whether or not things are really being done fairly. I think, again, I look at the equity lawsuit that's going on in our schools right now. The idea of equity is a synonym to the word fairness, and I think what that does is it opens us up to scrutiny on whether or not it's being done correctly. And so, again, I think that it's obviously desirable to be fair, but I think when you go down this path, you do open yourselves up to people to criticize whether it's actually being done in their idea, whether it's being done correctly or not. So again, I think we're better off right now where we're at. Again, we can always make a decision to go down this path should that be something we've got to contemplate down the road. But right now, I think it's just best to have a policy that allows that robust and thoughtful debate to happen when it's right before us. I'd like to recognize our legal.
Yeah, thank you, Chairman. Karen Powell, Deputy County Counselor. I think before we take a vote, we need a clarification on the motion. The actual recommended action is to take the action deemed appropriate by the Board of County Commissioners. If it's the intent of the board to support the change to the policy, then I would suggest the motion might state that the resolution that's included with the policy be adopted. The policy is incorporated within that resolution.
I think I did say that, did I not?
We have the motion that it was to take the recommended action. Since the recommended action is to...
Okay. Well, I think I went on to say to approve the policy, so let me clarify my motion is to approve the change to the Sedgwick County Grant Application Award Policy with the exception that on item G1 we delete the word "and." Is that okay?
Yes, that's fine, and also adopt the resolution to go.
And adopt the resolution.
Yes.
Authorize the chairman to sign.
Yes.
So that is my motion clarified. If my second will support that.
Your second will support that.
All right. Are we good to go ahead and vote now? I'm getting thumbs up. All right. We have a motion and a second. Any other discussion? All right. Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
No.
Commissioner Peterjohn.
Aye.
Commissioner Ranzau.
Aye.
Chairman Howell.
Aye. All right. Madam Clerk, next item, please.
Item F, Criminal Justice Program Review.
Good morning, Commissioners. Marvin Duncan, Public Safety Division. And today we'll begin with the Criminal Justice Program. And we'll be looking at first quarter 2016 and comparing it to last year's. First up is the average daily population of bookings, detentions, work release out of county. And the average daily population is a statistic that's captured in a snapshot of time. And it counts the number of inmates that are assigned to a particular location. And so the first area we'll look at is bookings. Bookings were up a little this year over the quarter last year by 30. Detention was up only about 16, and work release was up 27, which is good use of work release. And then out of county, that population was up 11. On the next slide, we look at the percent of municipal inmates that had charges from one arresting agency and charges from multiple agencies. And that there's a typo up there. That should be the first quarter 2016. But let's look at the bars on the right. March 31st, 2016, there were 1,366 inmates. And of those, 150 or 11% were being held on charges from one municipality. A number of hours billed to the Wichita, city of Wichita. Municipal inmates, and this goes back to when it was initiated in January of 2008. In January 2008, we had almost 198,000 hours. And in this March of 2016, we had 111,000 hours. So that's 87,000 hours fewer for March than it was 8 years ago. Next, we'll look at bookings and releases. For the year-to-date bookings, compared to last year, we have 169 more this quarter. For releases, though, we had 178 more releases than the last year's quarter. Here's the average length of the stay. The average length of stay, the booking is in hours, and so that's just hours on the length of stay in the booking process. Housing is measured in days, and then you see the combined there, that's both booking and housing. And because there are so many bookings, that's what drives down the combined, because bookings are in hours. Here's the average length of stay in booking, and we had been talking about booking hours going up over the last couple CJCC meetings. And one of the items is the sheriff had not seen so many violent crimes that he's seen earlier this year, and those take more time in booking. We also found in the sheriff's department, sheriff's office, that some of the inmates were kept in booking over the weekends that shouldn't have been. So we've corrected that, and so I did check April's booking hours, and it's dropped down to 20, and so hopefully we might see another drop this next month. Average length of stay, we talked about booking already. You can see how much higher it was this first quarter than last year. I think we've corrected part of that problem. Housing was up a couple of days, but then when you look at the combined year-to-date average, we're up 0.7 of a day over last year. Here's a slide that really tells us the effects that CJCC has had on the system, and these are the trends. Down at the bottom, you'll see the average daily population for booking, and for work release is in red, and for out of county is in green. And then the big driver is our detention population there in the middle in the blue. And then you add all those together, we're holding our own. It's kind of leveled out over the last few years. And one of the things we talked about at the last CJCC is what do we need to start looking at next to maybe possibly affect getting the numbers even lower than what we've kind of leveled out at. Here's the total monthly ADP, bookings, detentions, facility, work release, and out of county. You can see the history there over time. Here's the adult supervision snapshot. Day reporting won't exist anymore after this month. Pretrial services was up 66 over last year's quarter, and that's good. The DA diversion program is up, which is good. Scope is up a little, and that's good, and so is the drug court. So we're making good use of those other programs. Here's the adult supervision snapshot for other funded agencies. You can see most of them are Wichita there. Most of Wichita's other funded items are lower this quarter than they were last year for the first quarter. Corrections, the adult intensive supervision is 174 more this quarter than last year, so that's a good indicator. And then the adult residential is being used more. It had 17 more this quarter than last year. Here's a look at the BICE holds. We had 5 on March 31st. Here are the felony inmates that are in our system right now. There's 196. It dropped significantly. And then here's the long-term inmates. There's 62 inmates that are in the system for a year or more, and they have all the other things that you see below that mixed in with these 62. And I saw a huge spreadsheet trying to figure out how many have both pretrial, work release. It gets pretty complicated, but I think it's important you know that there's 62 long-term inmates in the system. So that concludes this briefing. If there are no questions or comments, I would recommend that you receive and file.
Thank you, Mr. Duncan, for the report. Commissioner Peterjohn?
Thank you, Mr. Chairman. I very much appreciate the report, and it's some important data in here for the community. And we've took a little action earlier today to talk about problems we had with potentially what can come out of Washington. But I remain slide 14 that you presented up here, Marv, that you talked about how there is a decrease, but it's still, if you go back to last year, there was a big jump in these numbers in terms of the number of felony inmates, and normally felons serve their sentences in the Kansas Department of Corrections, but because of state law that basically says they must serve, if they're convicted of certain crimes, they have to serve their sentences in the, I believe it's felony DUIs, and also if they write bad checks, they serve time in the Sedgwick County, or I should say this, in county jails across all 105 counties here. And since we've got 196 people, I mean, the work of the CJCC, and I think all of us who have followed CJCC closely, the excellent work that they've done in terms of being able to keep this community safe, but not overtax our detention facilities, whether it's the jail, work release, or anything else, deserves some credit. And to have roughly close to 200 people who are felony inmates in the jail, in that population, that is a very significant percentage. I mean, that's close to 20% of just the jail's capacity by itself. Okay, it's well over 15%. I'll pull the number back a little bit, and that's about 1 out of every 7 people who the sheriff has in custody. So I think the data in this report is very important, and it's a trend that we need to continue to monitor, because if this gets out of control, the costs of operating the statutorily mandated facilities that we have for public safety are going to increase significantly. So this is an important report, and Mr. Chairman, I'll make a motion that we receive and file.
Second.
We have a motion and a second. Other comments from commissioners? I have one question. What is the? Please remind me. What is the capacity of our detention facility here, the jail?
I don't have that number.
1,100. Oh, okay. Well, Commissioner's answering my question. He says a little over 1,100.
Okay.
So that's the number. I was curious, has the City of Wichita given us any official communication regarding their intention with the Day Reporting Center? Have they indicated their plan?
The last I heard, they were looking at some options.
Okay. So as of right now, as far as we know, we are going to shut down that program near the end of the end of June?
Yes.
Okay. That's the current plan. All right. And it was Commissioner Peter John's explanation on slide 14, that big jump. Is that a result of the state leaving some of the inmates that would normally go to one of their facilities, leaving them in our jail? Is that what's going on there?
I want to say yes, but I know you used to be a legislator, so
No, I don't.
I'll have to check.
I had no awareness that this was happening. I probably should have known this, but it seems like a tremendous change in the data starting there in about September of 2015, and it's very significant. So
yeah, I'll check with the sheriff, but I seem to remember there were some DUI things that came out of the legislature. Mark.
All right. We have someone that can answer the question.
Commissioners, Mark Bowen, management intern. There were a couple of things that have been discussed at CJCC recently. One of them has been that there have just been more warrants out than there has been in the past for felony crimes. The other has been there was one other issue talked about in terms of as was talked about a little bit with the Department of Corrections. I think there was one other issue, and I will look through the CJCC minutes today and get you some more information on that.
All right, that'd be great to find that out.
Mr. Chairman?
Commissioner Peterson.
Yeah, Mr. Chairman, if I can, in terms of this chart, I'm not familiar with any specific change that the state made that would explain the jump that occurred in the end of the third quarter, beginning of the fourth quarter last year. But this has been an ongoing, continuing problem, and I'm going to say several years ago, we managed to put a provision into the K.A.C. legislative agenda to basically request that the state remove convicted felons from county jails across the state. And we've had that policy in place. So these numbers that are here, I know this goes back, we're talking years, so I'm not sure why we had the spike last year. That's not related to any specific change that I'm aware of. And maybe there's more additional information from someone who's been following and perhaps been on CJCC that can explain that spike more recently. But it's been a long-term continuing problem, and whether we're talking about 100 prisoners, 150, or looks like here we actually went up to almost around 250, almost 250. I really believe that convicted felons ought to be serving their sentences in the Kansas Department of Corrections. Thank you.
Thank you for that clarification. And the only other chart that I have, this really pops up, and I guess it really needs to have an explanation. That would be on slide number 7. You said there was an increase in violent crimes, but obviously the trend line has changed drastically since about this time last year. I guess we need to understand what's going on there more deeply. Again, very concerning to see the trend going that direction so steeply. Yes, sir.
Yeah. Mark reminded me that the last time we talked to the sheriff about this, that it had been an unusually warm winter, and so people were more active outside. But we do have the issue where they were keeping people in the booking section that should have been in other areas of the detention facility, and they got added in. And so he's corrected that. It's coming down. April numbers, when I checked them, they were down at 20 hours. But the sheriff did say he had a lot of violent crimes early in the year.
Okay. And it would just make me wonder if some policies changed or some process has changed that's caused this data to jump. But anyway, any additional thought or analysis on that you might be able to develop and provide to us, that would be very welcome.
I'll do that.
All right. Commissioners?
Mr. Chairman?
Yes, sir.
Just to clarify, Mike Scholes, County Manager, on the number of beds in the jail. Commissioner Peter John is near us, 1,122 exactly.
Oh.
1,122 beds.
Very good. Well, thank you for the absolute number there. Appreciate that information. Commissioners, any other comments or questions? We have a motion to receive and file. We have a second. Any other discussion? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterson.
Aye.
Commissioner Ransaw.
Aye.
Chairman Howell.
Aye. All right, Madam Clerk, next item, please.
Item G, presentation of the Juvenile Justice Report.
Good morning, Commissioners. Marv Duncan again from the Division of Public Safety. And we're going to switch a little bit and look at the juveniles in our system. We always start off with the Juvenile Justice Services Continuum. This is kind of the stairway to the bad place, to jail, and how we can intervene or prevent as we work with those juveniles as they go through the system. It starts out with prevention programs in the upper left, and then ends up down in the juvenile correctional facilities on the right. Those boxes that have M in them are mandatory for the county to have those programs. Here are the prevention programs. The ones in yellow programs are funded by the Crime Prevention Juvenile Intervention Program. And then the green are those that are funded by Kansas Department of Corrections. The primary ones, which we don't have any right now, but they're directed to the population at large. The secondary column there in the middle is focused on the at-risk youth, and it's designed to prevent juvenile crimes before it occurs. And then finally the tertiary on the right, that follows the arrest, and that's when we get involved with those individuals. Here's the statistics on JIAC, the Juvenile Intake and Assessment Center. JIAC prevents youth from getting deeper into the system. They do assessments on the juveniles while they're there, and then they offer them referrals to take advantage of. 70% of the youth do take advantage of the referrals. They're there in an effort to help the youth avoid reoffending and becoming more deeply entrenched in the system. Most juveniles are brought in by law enforcement because they were suspected of some sort of illegal behavior. Here are the placement dispositions of JIAC. You'll see the red line there in the middle. Most kids that go to JIAC actually get released to their family. However, there are some that go to a shelter or detention or other, and those are down at the bottom. And then the orange line at the top is a combination of all those. Juvenile Detention Facility Admissions, which is what we call JDF, is a 24-hour facility. It has male and female offenders and alleged offenders who are waiting court hearings or placements by the state or in out-of-home placements somewhere. So you can see there the reasons, either a courtesy hold, a writ, warrant, new charge, and then the total of the JDF admits. There are 108 beds in JDF, but the facility is only staffed right now for 81. And so there's the trend of the population that's going into JDF. What's the cost? The cost is $229 per day, and the average length of stay is 21.2 days. This is a juvenile residential facility, and it's a residential staff secure facility, and it provides a less costly alternative to secure detention. You're probably familiar with it. It kind of sets off to the side of JDF, and the kids actually get on the bus and go to school from the juvenile residential facility. Community-based supervision, it's much like probation, and those numbers are up a little bit this quarter than they were at the end of 2015. The weekend alternative detention program, and I'm told that this is an interesting program where the youths have to get up on Saturday morning and go in for training, and their parents have to get up and get them there, so it gets the family involved as well. Graduated sanctions, there's 3 programs operated by Sedgwick County. The intensive supervision, probation, juvenile case management, and then the residential facilities are the YRCs, and then we have SKIP. SKIP's a 20-bed YRC2 facility for male offenders 16.5 to 21 years old. And it's designed to assist the juveniles in preparing for independent living. They get coaching and help with resume writing. They get jobs. I think there's a fairly high percentage that have employment. And then the 2 programs operated by the other agencies are Juvenile Division by DA's office and Juvenile Probation by District Court. Okay, here's what's going on in intensive supervision. It serves offenders on probation and ones that are at risk of entering state custody or some sort of juvenile corrections facility. The average ADP for this program is 146. Juvenile case management. Case management services are provided to juveniles in state's custody and those on conditional release. And the supervision term is usually about a year increment. And this is trending down slightly. Here's SKIP. We talked about SKIP a little while ago. The employment rate for those juveniles are 92%. SKIP was down in March, and in April it looks like it'll be about the same. It'll be up to 14 in April, so it'll jump back up a little bit. But remember, it's only a 20-bed facility. So here are the total funding costs for the juvenile programs. You see grant funds are a little over $4 million. Department of Corrections is funded for 7.6, and then Corrections has a maintenance fund that's about 1.2. So the total for Sedgwick County is about 8.8 million, and then the grand total is 12.9. Here's the cost of the mandated programs. JIAC at $692,000. JDF gets a grant of $191,000, but then Sedgwick County has about $6 million in that, and then there's the facilities cost again for the 7.2 total. JSIP is a grant, and then juvenile case management is a grant. Cost of other programs, there are prevention programs, Sedgwick County, the residential facility as a Department of Corrections. In the total from the general fund is about $1.45 million. Community-based alternatives, we have another $224,000 in there, and then SKIP is a grant, and it is $808,000. That's a quick look at the juvenile programs, and I'll stand for questions and comments, and if none, I'd ask that you receive and file a report.
All right, Commissioners, any questions or comments?
Mr. Chairman, I would move that we receive and file.
Second.
A motion and a second. Any other comments or questions? Same. Mr. Duncan, thank you for a good report. Apparently there's no questions, so you did a good job.
Well, I had good help from Mark Bowman, our intern.
I appreciate that. I have a motion and a second, and no other discussion. Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ranzoff.
Aye.
Chairman Howell.
Aye. All right, Madam Clerk, next item, please.
Item H, report of the Board of Bids and Contracts regular meeting on May 26, 2016.
Good morning, Mr. Chairman and Commissioners. Joe Thomas, Purchasing Director. The meeting of the Board of Bids and Contracts of May 26 results in 5 items that we'd like to present to you this morning. And the first item is the 2016 Nova Chip for Public Works. The recommendation is to accept the low bid from APAC Kansas Incorporated, Shears Division, in the amount of $4,164,608.47. Item number 2 is the 2016 Super Seal for Public Works. This recommendation is to accept the bid from Andale Construction Incorporated in the amount of $1,234,645.34. Item number 3, shredding services for various county departments. And this recommendation is to utilize the State of Kansas contract number 39005 with Underground Vaults and Storage, doing business as Document Resources, and establish contract pricing through March 31st, 2019. Item number 4 is the Prevention Early Intervention Services for the Division of Health and Human Services. This recommendation is to accept the proposals and execute service provider agreements for annual spends as listed above with Youth for Christ, the McAdams Academy, for $115,000, Kansas Legal Services for $25,760, Youth for Christ City Works Program for $60,000, the Pando Initiative Incorporated for $41,854, Mental Health Association of South Central Kansas for $54,300, Tile Spay Incorporated, doing business as Higher Ground for $95,000, Episcopal Social Services for $79,286, and Ember Hope for $187,952, and these would be for a contract period of 3 years. And our final item, item number 5, is the 2017 Ford Police Interceptor Utility, both the marked and unmarked vehicles for fleet management. And this recommendation is to accept the low bid from Rusty Eck Ford in the amount of $303,838. I'll be happy to answer any questions you may have, and I recommend approval of these items.
All right, thank you for the presentation. Commissioners, any questions or comments? What's the will of the board?
Mr. Chairman, I move we take the recommended action.
All right.
Second.
We have a motion and a second. Any other discussion? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ranzoff.
Aye.
Chairman Howell.
Aye.
Thank you, Commissioners.
Thank you. Madam Clerk, next item, please.
Consent agenda.
Mr. Chairman, Mike Scholes, County Manager, recommend you approve consent agenda items India through Alpha Alpha.
So moved.
Second.
We have a motion and a second. Any discussion? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ranzoff.
Aye.
Chairman Howell.
Aye. All right, Madam Clerk, next item, please.
Legislative issues.
Commissioners, do we have any discussion today for the legislative issues on the agenda? All right. I don't see anybody that wants to talk about legislative issues today. So, Madam Clerk, next item, please.
Other.
All right, Commissioners. Commissioner Ranzoff.
Thank you, Mr. Chairman. I want to address a couple things that were in the editorial in the Eagle today. I'm not going to talk to the main issue that it was about, but there's a couple things I want to clarify and correct for the record. First of all, they make a statement that the county commission's behind the scene role in a decision about a subcontractor in the road study. This is at least the third time the editorial page has given the impression or stated that the majority of the Sedgwick County Commission had something to do with the Bothner and Bradley issue. There's been 2 editorials that stated this and a cartoon that gave that impression. That is false. It is a lie. I'm not sure where the editorial board gets this idea. I don't recall anyone actually reporting that. I know I personally had absolutely nothing to do with it. But yet, the editorial board continues to lie to the community about this. And why would they do that? I find it very disconcerting. But then I'm not surprised. We're entering into an election cycle, so the propaganda, the misinformation, and deception will accelerate at every level, local, state, and federal. But when you use your platform to mislead and intentionally lie to the public, that's not helpful for the community. We have plenty of policy differences which are fair. But I would encourage the editorial board to review its criteria, its policies. Opinions, you're entitled to have opinions, but intentionally deceiving and lying to the community should be outside the bounds of, well, they should have higher ethical standards, I would say. Quite frankly, I think they owe the community, not the commission, I don't care about myself, but the community a retraction and an apology for intentionally deceiving them. Next issue, they brought up the issue about the agreement being extended November 18th. I think it's important to point out that the zoo board asked for an extension, and we accommodated that request. What were we to do? Say no? We accommodated it, and we made it, as the manager said, the latest date possible from a practical standpoint, so that give them the maximum amount of time, although we expect to have it done beforehand. But the fact of the matter is they couch it as if it's something that we forced them to do, when in fact they requested an extension and we accommodate that. That's about being a good partner. But nevertheless, I can make it a full-time job commenting on the false and misleading information you hear from the media oftentimes, and I can't do it, but on occasion I do take the time to correct it, particularly when misstatements about what the majority of the county commission did or did not, it's repeatedly misstated incorrectly, and I can only, if it's done repeatedly without any basis for it, I can only assume that it's intentional, and I hope to correct that for the record. Thank you.
Thank you for your comments, and by the way, I completely agree with everything you just said. Appreciate those comments. Commissioner Peterjohn.
Well, thank you, Mr. Chairman. I'm going to go in a slightly different direction this morning because I do plan to participate in the county's portion in the River Festival Parade Friday evening with at least one other member of my family, and I anticipate that there will be other folks participating too. I would like to see accuracy in all the news media, whether they're reporting nationally, state, or locally too. And but let me talk about June 1st for just a moment, because June 1st is an important day in American history. June 1st, 1990, President George H.W. Bush and the, at that time, Soviet leader Mikhail Gorbachev signed an agreement to end chemical weapon production and begin destroying stockpiles of these hideous weapons. On June 1st, 1789, President George Washington signed the first official act of Congress, and two very important events also occurred on June 1st for U.S. history. In 1813, the captain of the USS Chesapeake sailed out of Boston Harbor and engaged during the War of 1812 with the British warship Shannon in a ship-to-ship duel. And the Americans were in bad shape. The Shannon had one of the best trained crews in the Royal Navy. Lawrence had a inexperienced and very young crew, and the battle did not go well for the Americans. And Captain Lawrence, in charge of the American vessel, basically was mortally wounded and was carried below deck. He gave his last order, quote, "Tell the men to fire faster. Don't give up the ship," unquote. And despite this last command, Chesapeake was soon captured, and Captain Lawrence died a few days later, leaving behind a wife and daughter. A friend of Lawrence's, fellow naval officer Oliver Hazard Perry, heard of Lawrence's death and his statement, and he had his friend's dying words stitched onto a large blue banner which he flew on his flagship, the USS Lawrence, during the Battle of Lake Erie in September of 1813 during the War of 1812. Oliver Hazard Perry is not very well known, but we won that battle. The United States won that battle, and that flag now hangs in a place of honor in Memorial Hall at the United States Naval Academy in Annapolis, Maryland, with the words, "Don't give up the ship," and is now a rallying cry for the Navy. But there was something even more important that happened on June 1st, going back to 1774. In response to the Boston Tea Party, Britain closed the port of Boston. And interestingly enough, the colonies rallied behind the Massachusetts colony in this, and the Colonial Assembly in Virginia, including a relatively obscure retired colonial militia officer by the name of George Washington. Washington and his House of Burgess colleagues basically passed a resolution to engage in a day of prayer and fasting in solidarity with Boston. And this was a key event that led up to, obviously, the American Revolution, and in 1775, the shot heard around the world in Lexington and the Battle of Concord, Battle of Bunker Hill, and of course in 1776, the Declaration of Independence and all the events that followed. So June 1st is a very important day in American history. Wanted to provide that for the record this morning, Mr. Chairman. Thank you.
All right, any other comments from commissioners? All right, Mr. Manager, anything else to come before the board this morning?
Nothing else.
All right, well, we've completed our agenda, and we'll see you back here hopefully on June the 8th. Thank you. We're adjourned.
Production and broadcast costs for Sedgwick County Commission meetings have been underwritten by Sedgwick County.